With me now, CNN legal analyst and former federal prosecutor Shanlon. Let's get to the president's lawyers denying a former White House official's ability to answer really any question, claiming absolute immunity.
Right.
Does that exist?
It does exist. It's usually used more in the context of police brutality cases where officials have immunity. It's really qualified immunity, like if they're acting reasonably within the scope of their jobs. So it's really testing the boundary here. They're being very aggressive. There's almost a three-tier defense they're using. The first is absolute immunity, meaning they can't be compelled to talk, period. Second, they can go to the more traditional executive privilege. And third, there's Hope Hicks saying, I just don't remember.
Right.
And actually, it's kind of interesting, that last quote you just played from her, they should have objected to that. So they're obviously just cherry picking when they're letting her answer. There she's giving an answer that's very helpful to the president,
right.
So we're not going to object to that.
Right. So the Dems are going to challenge this in court. That might take some time.
Yeah.
I mean, politically, the president's clearly calculating he doesn't lose anything by just saying no to everything and that people will eventually get bored. From a legal standpoint, when they do eventually get to court, how is a court likely to rule on this stuff?
Most likely, the court will rule against such a broad assertion of complete immunity, even a very broad assertion of executive privilege. It is a ground game, though, and so Congress is trying to play the ground game. They're trying to lay the framework. Having them come in and object to all these questions lays a good record. Of course, the president's team is playing a ground game, too, and they're running out the clock.
Yep.
So I think legally the court should rule in their favor, but there is the sort of Hail Mary pass, to use a football metaphor here, where A.G. Barr certainly is a big believer in a imperial presidency. And so he's perhaps hoping that a conservative Supreme Court will go with him on that and grant a very broad deference to both executive privilege and immunity.
So Felix Sater, former Trump associate, essential to the broader Russia investigation, just simply doesn't show up this morning. His lawyer is claiming health reasons. I suppose that's possible here. But eventually, particularly if they issue a subpoena, he will have to show up and answer questions.
Right. And it's a bit odd because from the public reporting, he seems like he's willing to answer questions, even wanted to do it in public. It is normal you'd want to first meet with him in private with your staff and investigators to get a preview of what he's going to say. So I'm not sure why he's not showing up, whether that's a change of heart or not.
Let me ask you a final question on Hope Hicks. She said she only told white lies on behalf of the president. Now we know that she told some consequential lies because she was willing to lie, for instance, about the president's relationships with women, which folks might claim a reason to know about, but also payments to those women, which are now subject of an ongoing legal investigation. How does the law see what's a white lie and what's a lie?
I think the bigger problem for them, again, is they're cherry picking. They're being too cute with that. They want her to be able to characterize things that she wants to say as white lies because that's helpful to the president. But when you look at it legally, it's going to be, where do you draw that distinction? If you're talking privilege or immunity, there's not going to be only privilege or immunity for a big lie versus a small lie. It's whether you talk about it or not, and she's talking about it.
Shanlon, thanks very much.